with some apology, part 2, item number 2. Both of us had made a mention earlier also. The authorities and the APTC are also looking into the matter. You need some further time to clarify actually what the status is. May I pay for 2 weeks time, instead of part 2 list,
All right.
Maybe on the list.
May I pray for the urgent listing of a writ petition for motion for tomorrow, Your Lordship? We are challenging the draft delimitation notice issued by the ECI, Your Lordship, only in respect of one particular constituency, Your Lordship. Hearings were given to us, but we have come to know that our prayer has been rejected, Your Lordship, and they are about to issue the final notification any day. Once the final notification is issued, Your Lordship, the bar under 339 will come in, Your Lordship. We will not be able to challenge it. We have already filed.
Delimitation matter, what do you want the High Court to do?
Your Lordship, we have made out a case that under 332, Your Lordship, there is a manner in which constituencies are reserved for scheduled tribes, Your Lordship. That procedure has not been followed.
All right, you get it listed, but the law is quite well settled in these matters. You should be aware of it. Listing is allowed. Beyond that,
Obliged.
yes.
My lord, with the consent of the petitioners council, I beg to mention item number 7, my lord. I am for question number 1 to 5. Here I have to produce record, my lord. We need 3 weeks time, my lord.
On the prayer of Mr. K.K. Parashar and counsel for the respond numbers 1 to 5 made with the consent of the opposite party, admission hearing these matters stands adjourned for 3 weeks. So as to enable him to file affidavit. Interim order passed earlier to continue.
Obliged.
May it please, Your Lordship. My lord, I beg to mention item number 2 to 5, my lord, of the daily list. My lord, I have submitted one mention application. I have submitted one application, my lord. There is some difficulty today, my lord. Can it come after 2 weeks, my lord?
Other side, yes.
Yes, I have taken consent from the other side.
You are for the respondent.
For the petitioners, my lord, 2 to 5.
On the prayer of learned counsel for the writ petitioner, Mr. K. Mohammed, appearing in this batch of petitions made with the consent of the opposite party, admission hearing of these matters can adjourned for 3 weeks.
Obliged.
Lord, I am appearing for 4% part.
Mr. S.K. Talukdar, Learned Standing Counsel Cooperation Department, is present on behalf of the official respondent.
My lord, I pray for listing of a motion matter tomorrow. This relates to electricity disconnection, my lord, and petitioner is a cardiac patient, my lord, having some difficulty. Can come up
Is it
tomorrow.
before this bench?
My lord, bench.
Have you checked it up?
My lord, bench 4.
Bench?
4, my lord.
That's why I'm asking. This is bench 5.
My lord, electricity
You need
matters.
to read the.
Otherwise, electricity matters are, my lord.
Are you aware that bench 4 has been bifurcated?
My lord, into bench 5.
All right. You get it listed, but if it is not pertaining to this bench, matter rolls over.
Because other electricity matters.
I don't
my lord,
know.
are
There is
listed.
a notification. Check it up.
My lord.
If it is not before this bench, then no purpose will be
My lord.
served.
Ma'am, Lordship, I beg to mention for listing Lordship, WPC Lordship. It was last listed on 13th.
Last listed, you applied for the register. Then you come back. Make an application.
So I beg to mention some listing, madam, for admission, madam, relating to
Register. Make an application and then come back if it doesn't do it.
but matter is relating to no confidence motion, madam.
Motion?
Yes, ma'am. No confidence motion, madam.
No, you wanted listing for motion.
No, my lord, admission.
This is a whole pending matter.
Yes, my lord.
That's what I'm saying. You make a request to the register bench.
Okay, most of it.
Supplementary list for motion item 11.
Wait, please. Lordship. In this case, my lord, the under section 61 of the CGST Act, my lord, the proper person, my lord, on scrutiny of the return, if my lord, any my lord, discrepancy is found, for that my lord, a notice may be my lord, issued to the my lord, SSC for giving the explanation. Rather, my lord, this my lord, what it appears from this particular section, that it is for the benefit of the my lord, SSC, so that return can be corrected. At that stage, there is no my lord, question of forming any opinion whether there is an evasion or my lord,
GST.
well, I have quoted the provision in the section itself, my lord. Now here your lordship will find the notice under section 61 has been issued at page 17. Section 61.
Yes.
Now, my lord, the you notice, my lord, that page 17 has been issued. My lord, the
Yes.
discrepancy they have already, my lord, determined to be, my lord, evasion of tax. And thereby, my lord, so cause has been, my lord, issued as to why the penalty, my lord, should not be made along with the, my lord, other, my lord, the incidental charges, or otherwise to proceed under the, my lord, appropriate sections of law, my lord, at page 17, my lord. While analyzing the information received from the Additional Commissioner of State Tax Economic Intelligence Unit, Assam, Korbhavan District, Guwahati 6, it is observed that your generated e-way bill for inward supply of areca nuts having assessable value of 33 and odd crores, with amount of rupees 1 crore 69 lakhs, etc. during the financial year 2022-23, but on verification of EWBs in RFID record, it appears that there is no movement of goods of Assam. Further, you utilize this same ITC for discharging onward liability and thus avoided payment of tax in cash. Hence, this is a case of evasion of tax. Moreover, it is observed that you have not made any reverse charges payment against purchase from the unregistered parties assessable value amounting to 67 lakhs and odd. Details have been given. You are hereby asked to show cause in writing why tax and applicable interest will not be levied and penalty as per GST law will not be imposed upon you based on the amount shown in the table. You are asked to give explanation relating to discrepancies shown so and so. Well, they have already determined that this is an evasion of
No,
tax.
no, yes.
That procedure will be coming only after the 65, 67 or the 73.
No, you are to submit your explanation.
Lord,
You submit it. Whatever your stand is before this court, you first place it before the authority.
One
and
of the discrepancies, what is from my return, that has not been indicated in the notice. Your Lordship will kindly see. That they have made some verification in the RFID form, and according to them, the goods have not come to the Assam.
But
that
what
is-
will the writ court do about it?
my lord,
What can the writ court do about it?
my lord, I have come for violation of the my lord, as I have said, my lord, under section 61, there is a benefit for the the SSC.
No, but on what basis you are saying it was passed under 61?
Because Lordship will find my page 17, SMT 10, my lord.
SMT 10 means?
SMT 10 is a prescribed form under section 61. And that also reflects,
No,
my lord, in-
Mr. Sekya, what I'm asking is,
yes,
they may be right, they may be wrong. But if they have issued a notice asking your reply, why don't you file and reply? We'll ask them to consider it before taking any action.
Lord, exact discrepancy what I have from the return, my lord, that is, let them, my lord, mention that, my lord, so that I can explain, my lord. But here it is not that they have, my lord, as I have, my lord, Lordship has seen the notice, my lord. Some devices they have seen the, my lord, where from, my lord, they have come to a conclusion that the goods have not been, my lord,
So you take a stand that there is no mention of discrepancy, there is no discrepancy, that's all. We'll see how they deal with it. See, Mr. Sekya, these are matters you know how it operates. The writ court will not go into the sufficiency. Writ court will only see whether the procedural requirement has been followed or not, or whether the decision is arbitrary, perverse. They have rightly or wrongly issued a notice upon your client. You submit your reply. That reply could be one of the grounds could be that no details is furnished. And if the stand is ignored by them and then coercive order is passed, then you can challenge it before the court. But today, what is there for the writ court to do in this matter?
my lord, as I have, my lord, already pointed out, section 61, my lord, the opportunity to explain, my lord, with the discrepancy that is found in the return. They have,
That is why they have given you a.
but they have not mentioned it in the notice. Lordship has seen, my lord. They, according to them, my lord, the goods have not come. My lord, this does not reflect from the, my lord, returns, my lord.
Therefore, you submit your.
Lordship will
request.
indicate, my lord, in the order, my lord, that all the submission, my lord, that, my lord, what, my lord, I can, my lord, submit and they'll consider, my lord.
Yes, Mr. Govind.
Only thing is, my lord, the
Your
last. that has-
GST.
Yes, ma'am. Lordship will see, my lord, page 16, the
Hmm.
date, my lord, as per the, my lord, provision of the statute is, my lord, 30 days. And he was supposed to give the reply by 3/8/2023. After this date, my lord, even after giving 1 month, he has approached his honorable court, now challenging this order.
We'll give you one more week from today.
That-
I take down hard Mr. PG Sekya, Learned Senior Counsel, assisted by Mr. R.S. Mishra.
One thing, my lord, by now, my lord, if any coercive step has been taken, so can it be after some time, at least let me have the instruction, my lord, because otherwise again, there will be difficulty. 30 days is already over, my lord, on 3/8.
My lord, I have submitted my lord representation before that. I am approaching the court, my lord. So therefore, perhaps they have not taken any.
Just to
Question
that-
of coercive action doesn't come because they'll proceed
No, no,
under
Mr.
section
Mr.
65,
Sekar,
67.
Mr.
Maybe,
Sekar.
my lord, he is not aware.
This business of representation doesn't work everywhere.
Okay.
These are functions of the GST authorities by invoking powers under the statute. You can possibly question that on two counts. First, the exercise of powers is divorce the law. And second, the basis is not there, which would mean that the decision is perverse. Apart from that, perhaps there is no other ground on which you can challenge it.
Yes, yes. my lord.
So representation will not
No,
work out.
representative for the, I mean, I am submitting against the submission that coercive action might have taken against that what I have submitted, that I have taken, no action has been taken. And rather, my lord, from the notice itself, it says that they may proceed under section 65, 67, etc. My
Yes.
lord. There also, my lord, they have to issue a notice which I have not received. So, my lord, question of an
That is-
issuance of
Or
those
day after
notices
tomorrow,
have
my
not
lord,
arrived.
passed out, I have nothing
No,
to
no,
say.
not day after tomorrow.
After some time, my lord. Yes, I
10
will have
minutes,
to-
wait for 10 minutes.
Item 12.
May I please, Your Lordship? My lord, this petition, we got this impugned notice at page 29. I just summarize the fact, because the issue is very short, although the brief contains a lot of documents. The railways may not have a policy under 2010 policy where these licenses were issued. There, it provided a provision, there was a provision for renewal. I'll show your lordship that. Now, 2017, a new policy was introduced where your lordship could not find a provision for renewal. Now, there is a clause, which is clause 20 of the 2017 policy, which says that if the LOA, letter of award, was already issued under the 2010 policy, then that policy will govern the field. So the crucial thing is, when was the letter of award issued? In our case, it was during the period when 2010 was continuing. Therefore, my lord, the short point is that in any view of the matter, under the 2010-17 policy also, you are bound to renew because you have left it to the earlier policy, so far as some of these licenses are concerned. That's the short point. There are a large number of cases pending, my lord. We have annexed there. Apart from the court's order, the government of India, the railway department, they have issued to all the railway zones that maintain the status quo as prevailing in August 2019. So that also is breached by them. This is the only zone in Lumding zone which is doing that. I have annexed, my lord, the orders. I have annexed different zones, my lord, Western zone, Southeast zone, where they have said that yes, this status quo will continue as far as these licenses are concerned. So that's the short point, my lord. On this, my lord, our High Court also, we have filed several cases. In one, at least this clause 20 has been referred to, my lord. We have annexed that order also. And that matter, another matter which is gone to the division bench, there also division bench has maintained a status quo order, which we have annexed. So that short point is, my lord, now whether clause 20 of the 2017 policy will apply. Just have a look at that for a moment, my lord. 2010 policy, my lord,
Yes.
is at page 66. And that relevant clause is, my lord, clause 16 at page 80. Kindly have a look at that. at page 80, clause 16.
Mhm.
This 16(1)(3), last clause of that.
Yes,
Allotment of all general minor units at A, B, and C category stations shall be awarded for a period of 5 years, with a provision for renewal after every 3 years on satisfactory performance and payment of all dues and arrears, and withdrawal of court cases, if any. Allotment of all general minor units at D, E, F category stations will be for a period of 5 years, with a provision for renewal after every 5 years for a further period of 5 years on satisfactory performance and payment of all dues and arrears and all that. So this provision was there. Our letter of award, we got, the tender process started in our case. Tender notice is at page 91. It is dated 2014, 24/6/14. At page 91, it is 17/6/2014. Then we were given the allotment, which your lordships will get at page 163. This is dated 12/12/16. And then, comes now the 2017 policy, which your lordships will get at page 184, and it is dated 27/2/17. And if your lordships will kindly turn to clause 20, which is at page 179, kindly have a look at that.
yes.
Clause 21, my lord. It will be effective from the date of the issue. Date of the issue is, my lord, 27/2/17 at page 164. Then subclause 2, 22. Tenders that have been finalized and LOA issued prior to the date of notification of this policy. Your lordship has noted our LOA was given on 7 LOAs of 12/12/16,
Yes.
before the coming into force of 2017 policy, shall be allowed to continue as per policy guidelines prevailing at that time. Zonal Railways will cancel all such tenders and return the earnest money to the tenderers in cases where LOA has not been issued before issuance of the circular.
You are reading from which page?
Milord, I am reading at page 179,
Clause?
clause 20, last clause of that page, Milord,
Mhm.
20.2. Tenders that have been finalized and LOA issued prior to the date of the notification of this policy shall be allowed to continue as per policy guidelines prevailing at that time. Zonal Railways will cancel all such tenders and return the earnest money to the tenderers in cases where LOA has not been issued before issuance of this circular. So in case it is still pending when the circular comes, then 2017 takes over. If it is already LOA has been issued, then they say that it will be according to the earlier policy. So that is the issue which is pending before this court, in several cases, including the division bench. Therefore, when we got this, I must bring it to your lordship's notice. Initially, we filed an interim application in a matter of the petitioner, but really the subject matter was not, relating to this. It was with regard to the license fee during COVID period. Therefore, we all thought that we should file a substantive petition. When the matter was, we mentioned it came up before Justice Debashish Borua. And I told that frankly, and my learned friend also said that subject matter of the writ is different. Therefore, but I said that this matter is pending before the courts. There are interim orders. So give me this protection till I file a substantive petition, which his lordship did. And the learned counsel appearing for the railways bureau fairly said that he will see that no. That order. That is an order which was passed. So he undertook, below that is recorded, that no coercive steps will be taken till recess. So we are still in possession, we have not handed over possession. And we propose to, below, this is coming today also before Justice Bolwan. We'll withdraw that application, below, because really speaking that we should have filed that substantive petition, which we said also. Let me consider along with all these matters, if your lordship see the government orders also, we have annexed that, there are several status quo orders.
Yes, where are the orders, page number?
Page below 185 onwards, below. If your lordships just take up this is a very 186 also is there, 187, 188. That is Western Railway. And Government of India is at 189. And asking that the all the status quo should continue as of 19. Conclusion.
Yes, Mr. Gupta.
And
This matter,
Central Railway, Western Railway, all this we have annexed.
may I please? My lord, the impugn order is at page 29. And my lord, if I may reach page 30. Because my lord, here the petitioner has not annexed the agreement, my lord, which has license agreement which was entered into. That agreement, my lord, contains a period specifically stating that the license will be valid from this particular period, and after that there will be no renewal. So my lord, I may just read page 30, which gives the reason for the
That
order.
license was valid for how long, according to?
My lord, it was valid page, my lord, 29 is the period. It was valid up to 1/10/2022, and thereafter, not on the account of COVID, it was extended up to 31/7/2023. Now that period has expired. The period of tenure has already expired. So my lord, and new catering policy 2017, my lord, that provides for a tender process. And my lord, the clause which the interpretation which was read, my lord, perhaps is not correct, because if that be so, my lord, then all the previous, then the catering policy 2017 would be of no use.
No, but have they made any application for renewal?
Yes, yes.
I don't
It
know.
is there.
We have.
Because if it is after the expiry of the period, my lord,
We have made the renewal, if your lordships kindly see at page 163, our LOA order itself, 12/12/16.
that is not for renewal, my lord, that is
This
different.
is the first order. This is
Like-
where we.
When was the application for renewal made by the petitioner?
My lord, thank you, your lordship. Just,
Made last year on November 10, 22.
It has not been annexed.
Last, few days back on 25/7/23, another renewal application.
My lord, under the new catering policy, my lord, there is no scope for renewal, my lord.
No,
If I may
that
read
is
page
the
175.
if the new policy applies, he is right, but his own policy contains clause 20.
No, my lord,
And
clause,
LOA
lord,
admittedly
clause-
was issued prior to 20
My lord, the
27.
clause 20 has to be read with clause 11, my lord. Clause 11, my lord, will take page 175 for a moment, my lord. Page,
No, in this
So,
matter.
Mr. Gupta, you see, there is no point making this submission
Yeah.
because your previous policy clearly says that they
No,
will
my
be
lord.
entitled to, and that will
but
be
it is
applicable.
only, my lord, up to the previous contract, if the term has expired,
Hmm.
then thereafter, my lord, there is
Show
no
me,
renewal.
show me, show me.
Page
show me.
175, my lord.
Yes.
217, page 175, clause 11, that is, this is the new catering policy of 2017, which
That
deals
is-
with tenure. Clause 11, my lord, page 175. Tenure of, my lord, may I read?
Hmm.
Tenure of all major units being handed over to IRCTC will be governed as per the catering policy 2010 till the expiry of the contracts. IRCTC shall further manage these units as per the provisions of this policy. That is 2017 policy. So, my lord, these are all major units.
No, no, no.
The moment the terms are.
It's minor, you are not.
My lord will take,
This is a minor. unit.
my lord will take
And then-
11.2.
Don't make the submissions.
My lord,
I record it. in
Since they
your-
have not
No, no,
annexed
this
the
is
agreement, my lord, I also don't know whether they are major unit or minor unit.
Then why are
There
they-
is no awareness, my lord.
Their own policy.
My lord,
says
11.2
What are major and what is.
My lord will
minor.
take 11.2
Oh,
thereafter.
These stalls will not in the platform, they're all general minor units.
My lord will take
I
11.2,
think,
which deals with minor
either he
units.
should take instructions.
Tenure
or he
of
should
food
not
plaza
take
shall be for a
instructions.
period of 9 years. Tenure of all other catering units, major and minor units, will be for a period of 5 years only. There will be no further extension renewal except for these units specifically referred to in para 3.8.1. So, my lord,
This
if
is
the
the-
previous persons are allowed to, what is the use of that catering policy 17, which has
We
been?
are not concerned with what.
Hello.
you
If you
use
have
and
clause
what you
20 years.
Mr.
then-
Gupta, the manner in which you submit before the court draws displeasure of the court. This is not the way to make submissions. You are not meeting the points, the arguments advanced by the senior counsel on merit. What is the use, what is not the use, none of
No,
our
no.
business.
I'm sorry, my
You
lord.
go and talk to your officers and figure out.
My lord,
We are
but
not here
my
to see
submission.
what is the use.
My lord. My lord, the reason.
Mr. P.K. Goswami, learned senior counsel, instead by Ms. Ms. Chaudhary, learned counsel appearing for the petition. Assigning the notice dated 1/8/2023 issued to the petitioner number 1, asking it to vacate the stall number GHY-1 at PF number 1 at Guwahati Railway Station. Upon completion of the contract period, the instant writ petition has been filed. Full stop. According to Mr. Goswami, learned senior counsel for the petitioner, the LOA in this case is dated 12/12/2016, and therefore, as per the as per the professed norms of the IRCT, the agreement of the petitioner would be covered under the 2010 policy. Mr. Goswami further submits that as per clause 16.1.3 of the 2010 policy, as per
Page
clause
81,
20,
page 81. 20.2.
as per clause 20.2 of the policy of 2017, the LOA issued under the 2010 policy and the agreements entered thereunder would be governed by the said policy, and therefore would be entitled to consideration of the request for renewal of contract. The learned senior counsel submits that although the petitioners have submitted an application for renewal of the contract public license for a further period of
The period is 5 years and 5 years. Under that,
further period of 5 years. The same has not been considered till today. On the other hand, the respondents are seeking to evict the petitioner from the aforesaid stall. thereby causing serious prejudice to their interest. Mr. Goswami has also invited the attention of this court to the instruction dated 29/5/2019 issued by the Assistant Commercial Manager, Beckett Catering, Beckett Officer for Annexure Capital J, to submit that instructions have been issued to all authorities to maintain status quo with regard to minor static units beyond 31/3/2019. Moreover, submits Mr. Goswami, the question as to whether the petitioner's agreement would be covered by 2010 policy or the 2017 policy is a issue which is sub judice before this court in a batch of writ petition, including WPC number 2676 of 2023, where an order of status quo is operating. Under the circumstances, the present is a fit case where an interim order of protection should be passed by this court. First up, responding to the above arguments, Mr. Gupta has argued that the that after the expiry of the agreement, the authorities would have to float tender, as otherwise the same would render 2017 policy as infractious. First up, the learned CGC could not, however, appraise this court as to whether the authorities have received the renewal application from the petitioner, and if so, whether any decision has been taken in respect thereof. First up, having regard to the expressions used in clause 20.2 of the policy of 2000 policy document of 2017, as well as the facts and circumstances of the case, this court is of the prima facie opinion that the application for renewal, renewal of license, if any, made by the petitioners would deserve proper consideration at the hands of the authorities. Full stop. Therefore, this matter would call for further examination. Stop. Issue notice of motion returnable on 30th of August 2020. Mr. Gupta has appeared and accepted notice on behalf of all the respondents. No formal notice is required to be sent in this case. Extra copies of the writ petition be furnished to the learned department counsel, requisite in numbers, so as to enable him to obtain instruction in the matter. First, part of the prayer of interim relief, the said prayer will be considered on the returnable date. However, having regard to the peculiar facts and circumstances of the case, and also the fact that a series of writ petitions involving the same issue is pending before this court, as an ad interim measure, it is hereby provided that status quo as regards the possession of the petitioner over the stall in question shall be maintained till the returnable date. Register to list this case along with WPC model 12 and the batch of connected writ petitions.
For admission, part of matter, item 13 and 14.
May it please your lordship. Lordship, in this case, I pray before your honor to give some time. We want to file an additional affidavit, lordship. In fact, the last direction was to taking instruction to the AG, whether the increment has been withheld or not. There is a law point involved, lordship. We want some time. We'll file an additional affidavit. This
How much time you want?
2 weeks, my lord.
Lordship.
Let it be clarified, the law point, lordship.
Chair and Burman Learned Counsel appearing for the writ petition in view of the legal issues arising from consideration of this court in the matter in these writ petitions. 2 weeks. You take 4 weeks time.
Lordship.
4 weeks time is required to file an additional affidavit. First up, since the prayer is not opposed by Mr. H. Sharma learned additional senior government advocate as well as Mr. R.M. Das, learned standing counsel, water resources department, appearing for the official respondents, the same stand allowed. Let these read petitions be listed again after the additional affidavit is brought on record on behalf of the petitioners. The respondents may file rejoinder if so advised. These read petitions shall, however, not be treated as parted before this court any further.
My lord, lordship, there was direction for keeping one post vacant. There earlier interim order.
That is there.
That is there, my lord.
And
I'm deeply obliged.
Lord.
Daily list for admission, item 1.
My lordship. Very short issue, your lordship, that
How short? How short?
absolutely short, your Honor. The only the issue is that one road over bridge that is proposed to be constructed. 13 petitioners before your lordship. Our only contention before this before the court is this 1964 Act not applicable, so far the award and compensation is concerned. 2013 Act will be applicable. And to that effect, your lordship will place the judgment of our High Court, your lordship, our honorable High Court. Clearly says that the acquisition is in permanent in nature, then 13 will applicable. That is the only issue.
Let's get the facts of the case first.
Facts, your lordship. But you will find that there are 13 petitioner. All are having a small show. In para 5 of our application, REIT application, you have stated,
Just a minute, then let me find out what is the fact.
Lord.
These are all Sarkari land, government land.
Absolutely. We are covered within the definition of person interested in lotteries with Act 2013 comes.
Give me the act of 2000.
We prepared a short note, may I place it?
No, Olga Tillis is a pavement dweller. That's
Yes.
a different matter.
Yes.
It's not connected with this.
We
Anyways, now, what is the issue here?
covered with the Sarita Tony case of our High Court. Next page.
Which is the section dealing with persons interested in land?
Section 3, X 5, Roman 5. Your Lordship.
Section 3,
Section 3, X Roman 5.
yes. All right, now,
Please read that. Yes.
yes, the judgment is there.
Yes, para 24.
So what is the relief you are seeking here?
Actually, already the notice has been issued, publication was made. Only that if your lordship deem it fit and necessary, your lordship, the direction to assess the compensation as per Act 2013,
And where is the notice?
page 65, your lordship.
Actually, this notice has been issued to all the petitioners.
All the petitioner, your lordship. And the respondent authorities are also filing affidavit in reply. And lordship will kindly have a look at page 106. There is a report of the deputy commissioner.
Yes.
The purpose of acquisition of the land that has been mentioned there.
Yes, who's appearing?
My lord, we have not filed our affidavit, my lord, from deputy commissioner. My learned friend appearing under revenue department, they have filed their affidavit. And stand taken by the revenue department is my lord, they are entitled for getting the compensation for year under the old act, 1964 act. This is the stand taken
No,
by
why
the,
older? This matter has been gone into by the court in the case of Sarita Soni and others.
my lord.
The learned single judge has held that it's a permanent acquisition. Therefore, it will come under the 2013 Act.
That I have not come into, my lord. I have not gone into that judgment, my lord.
You want to have a look at it? Para 24. In the meanwhile, we'll ask you to address the court.
My lord, before that, my lord, your lordship may kindly see the affidavit in opposition filed by the revenue department. And the page relied by my learned friend, 106 of the said affidavit.
Yes.
Last paragraph, para 7 at page 107. my lord.
Yes.
That the said plot of land under tag number so and so is of central government railway, which petitioners are unlawfully occupying by the by constructing structures. Since the process of acquisition of said plot of land is being carried out for public purpose and as per the Assam Land and Revenue Regulation Act 1964, and all requisite notice published as per prescribed format of the Assam Land and Revenue Regulation Rules 1964. I would request you to kindly place the matter before the Honorable Court for rejection of the petition, so that the land acquisition process can be completed immediately. That is the stand taken by the.
No, that could be stand, but then the point is, this issue has been resolved. And if it is 2013 Act, then their claim for compensation has to be processed. What is the other option available? Yes, Ms. Borderley, what do you have to say? You are the one who has filed the affidavit.
Yes, Your Worship.
They are earning their livelihood
Yes.
by running shops over the government land. Therefore, they come within the definition of affected person, interested person.
Lordship, the notice was issued under section 6(1) of the Assam Land Acquisition Act of 1964, Your Lordship.
That's correct, but that's what his case is. That it is the Act of 2013 which will be applicable here. Because it is a permanent nature of acquisition.
Yes.
You can't remove the bridge after some years and hand over.
Yes,
That's
yes.
right.
And 1894 Act that was repealed, Your Lordship.
How will the 64 Act come in?
Section 11 of the 64 Act says the compensation has to be assessed as per Land Acquisition Act 1894. That was not in existence as on today, Your Lordship. Section 11 of the Act 1964. Subsection 3.
So what is your answer to that?
Lordship, regarding this issue on last occasion, the Honorable Court had directed the senior.
Oh, don't get into all these things. What is your stand? You make it and then take
My
your seat.
stand is, Your Lordship, the compensation would be paid as per 1964 Act. Everything has been done according to that act, Your Lordship.
Where is the Land Acquisition Act 1964? How will you then compute the compensation? How will you calculate the compensation?
Section 11. Section 11. अभी हम follow some. Let's see. Section 11, subsection 3, Lordship kindly have it. And section 114 of the Act 2013 says is repealed, Your Lordship. Section 114.
So if 64 Act is applied, then you don't get any compensation.
Absolutely correct, Your Lordship, because the assessment under Land Acquisition Act that is not in existence as on today. It has been repealed in 2013 itself. Therefore, this Honorable Court says that 2013 that would be applicable.
All right. So that's it.
Yes, your lordship. They are only entitled for the Zirat, your lordship. That will be falling within the purview of the 1964 Act, your lordship.
Heard Mr. B. Dattal, and senior counsel listed by Mr. S. Dekal, learned counsel appearing for the writ petitioners. I've also heard Ms. N. Bodoloi, learned standing counsel, Revenue and Disaster Management Department, Assam, appearing for the respondent number 1. And Mr. D. Sharma, learned additional senior government advocate, Assam, appearing for the respondent numbers 4 and 5. None is your fault. Mr. B. Gogoi, learned SCPWD, has appeared for respondent numbers 2 and 3. The writ petitioners herein, numbering 13 in total, are admittedly in occupation of Sarkari land, whereupon they have their shops which are being operated by the respective petitioners for earning their day-to-day livelihood. Full stop. Agree by the notices issued by the Deputy Commissioner Tinsukia, namely the respondent number 4 here in full. Dated, all the notices same date.
Yes, yes.
Dated 13/5/2022 under section 3 bracket 1 bracket close of the Assam Land bracket Requisition and Acquisition bracket close Act, 1964. Directing the petitioners to hand over vacant possession of the land in question, which was required for construction of a railway overbridge. Is it railway overbridge?
Road overbridge.
Road overbridge.
Road
Bracket R, small o, then capital B. The instant writ petition has been filed. Inter alia contending that since the land will be required permanently for the purpose of construction of a ROB, there was no scope of returning the land. Therefore, the provisions of provisions of the Act of 1964 would not have any relevance in the matter. First, on the contrary, according to the petitioners' counsel, it is the right to fair compensation and transparency in land acquisition, rehabilitation and resettlement act, 2013, bracket hereinafter referred to as Act of 2013, which alone would have relevance in the present proceeding. First, by inviting the attention of this court to the definition contained under section 3 bracket small n, no, not small n, section 3
You the other section 3 to cause 3.
X, bracket of small x, bracket close, then again bracket small Roman 5, bracket close. Mr. Datta, learned senior counsel for the petitioners, submits that the writ petitioners are all the writ petitioners come within the definition of within quote person interested unquote insofar as the acquisition process is concerned. Since the improved notices had been issued on 13/5/2022, that is after coming into effect of the Act of 2013. Hence, the proceedings would be governed by the provisions of the Act of 2013 alone and under no other statute system. By placing heavy reliance on decision of this court rendered in the case of Sarita Soni and others versus State of Assam and others, reported in 2020, bracket close, 1 GLR 136. Mr. Datta has argued that while deciding an issue of similar nature, the learned single judge has categorically held that land required for construction of bridge would be of permanent nature, and therefore the provisions of section 3 bracket numerical 1 bracket close of the Act of 1964 would not have any application in such case. Rather, it is the Act of 2013 that will apply in this case. Full stop. Ms. Bordoloi, Learned Standing Council, Revenue Department, Assam, has invited the attention of this court to the amendments made in the counter affidavit filed by the respondent number 1 to submit that this is not a case to submit that the notices issued under the provisions of section 3 bracket numerical 1 bracket close of the Act of 1964 were valid in the facts and circumstances of the case. Full stop. The learned departmental counsel, however, could not respond to the query of this court as to how, after the repeal of the Land Acquisition Act of 1894, and in view of the law laid down in the case of Sarita Soni and others, bracket Supra, the impugn notices would have been issued to the writ petitioners under the provisions of the Act of 1964. First of, the learned counsel appearing for the remaining respondents have reiterated the stand taken by the respondent number 1 in its affidavit, which has been noticed herein above. First of, in the case of Sarita Soni and others, bracket Supra, the petitioners therein had joined together and filed a writ petition questioning the validity of the notice dated 31/5/2018 issued by the collector in exercise of powers conferred under section 3 bracket 1 bracket close of the Act of 1964. For acquisition of a plot of land mentioned therein for construction of bridge, is it?
Road over bridge.
Huh?
ROB, road over.
In that matter, Sarita Sani,
Sarita Sani is the North Guwahati
for construction
of the
Of a
Brahmaputra
bridge.
North, bridge over Brahmaputra North,
bridge over
not Brahmaputra.
river Brahmaputra.
Yes.
First up. While allowing the, according to the writ petitioners therein, it is the provisions of the Act of 2013 which alone would be applicable in the aforesaid case, and therefore the notices issued under section 3 bracket 1 of the Act of 1964 were required to be quashed. First up. While answering the question in favor of the petitioners, the following observations were made in paragraphs 22 and 23 and 24, which are reproduced herein below. Mr. Having regard to the facts and circumstances of the present case, I am of the opinion that the decision rendered in the case of Sarita Soni and others would be squarely applicable to the facts of the present case as well. Full stop. So you are to, in this judgment, appeal to be preferred before the land revenue. That is the petitioners were asked to prefer an appeal before the government. You also prefer an appeal?
Before the collective,
No, you have not read the judgment, para 26.
Lordship.
Please read it. Do you have a copy?
I have two
Oh,
copies before this
all
honorable
right,
court.
all right. Leave it back. What was the relief granted in this Sarita Soni?
Lordship. Para 26.
Before the revenue department, your lordship, within 30 days.
That will do. Lordship. That will.
In view of the above, this writ petition is hereby disposed of by granting 30
Or in
days.
alternatively, if your lordship kindly,
Huh?
in alternatively, because the authority is district collector.
Hmm.
In Act of 2013 also to assess the compensation. Your lordship. There,
No, why this matter was sent to the government? There must be some statutory provision.
Lordship, in paragraph 25, it is stated that it is only the petitioners who have expressed their grievance and not all the persons mentioned in the schedule.
that is, we are only the persons who are served with the
Maybe
petition.
for
Lordship.
that reason.
No, is there a provision of appeal before the government?
No, as per the 2013 Act, there is nothing, your lordship. It is the authority itself to take a call for assessment, your lordship. So therefore, your lordship may direct, if your lordship deem it fair, it necessary. Deputy Commissioner, District Collector.
Paragraph
This
24.
this writ petition is disposed of by permitting the petitioners to approach the respond number 4 by filing individual applications asserting their right under the Act of 2013 in the matter. Full stop. If such application is filed individually by the writ petitioners within 30 days from today by enclosing a certified copy of this order, the same may be considered as per law, and appropriate steps may be taken in the matter for redressal of grievance of the petitioners. Full stop. Until such time the aforesaid act is completed, status quo be maintained as regards the land under occupation of the respective petitioners. Writ petition stands disposed of.
Greatly obliged.
I'm obliged, your lordship.
Well, no action has been taken yet, madam. Lordship may dispose it of giving them at least minimum at 2 days time, or 2 weeks time, madam. Because last we have given 30 days time.
All right.
So within two
Heard
weeks, they will
Mr. P.J.
respond.
Saikya, learned senior counsel, assisted by Mr. R.S. Mishra, learned counsel appearing for the writ petitioners. Also heard Mr. B. Gogoi, learned standing counsel, GST authorities, appearing on behalf of the respond numbers 1, 2, and 3.
Well,
First of all, assailing the notice dated 03/07/2023 issued by the Assistant Commissioner of State Tax, Guwahati, Unit B. That is the respondent number. Respondent number 3 hearing. Directing the petitioner to show cause within 30 days of the date of receipt of the notice as to why. An amount of rupees 67 lakhs 03,019 should not be levied upon the petitioner as unpaid GST dues.
A total 1,73 lakhs.
And penalty, what is the balance amount?
Well, the total amount is 1,73
Actually,
lakhs.
1 crore, not 1,73 lakhs, 32,000 888 should not be levied upon the petitioner as the unpaid GST dues along with penalty. Full stop. Mr. Saikya submits that the impugned notice has been issued by invoking the provisions of section 61 of the GST Act. GST Act 2017. However, the basis of the action is not a reassessment of the returns submitted by the petitioner, but inputs received from external sources, and therefore the impugned notice is not maintainable in the eye of law. Full stop. It is also the submission of Mr. Saikia that the impugned notice does not reflect the basis on which such allegation has been brought against the petitioners, as a result of which they are unable to make an effective reply
Deficiency in the returns.
Huh?
Deficiency in the returns.
with regard to deficiency in return, in filing of return, if any, in the matter. Full stop. Mr. Gogoi, Learned Departmental Counsel submits that since these issues can be raised before the GST authorities, the writ petition be disposed of by directing the respondents to consider the grievance of the petitioner after considering the show cause replies submitted by them. Full stop. After hearing the submissions made by Learned Counsel for the parties, and also upon going through the impugned notice dated 3/7/2023, I find that I find that any decision is yet to be taken by the authorities on the aforesaid complaint. However, since some serious allegations have been brought against the petitioners, they would be entitled to complete particulars as regards the deficiency, if any, in filing the return before an effective reply can be made by them. Full stop. Therefore, this writ petition is disposed of by providing that within 2 weeks from the date of receipt of a certified copy of this order, the respondent number 3 shall furnish full and better particulars to the petitioners as regards the nature of deficiency brought against the petitioners in the matter of filing of GST returns by giving them 3 weeks further time to submit their reply, facilitating above the petitioner to produce a certified copy of this order before the respondent number 3 by tomorrow. That is, give the dates. So and so. Mr. Gogoi may also communicate the matter to the departmental authorities. Until such time, the aforesaid exercise is completed and a reasoned order is passed after taking note of the show cause reply submitted by the petitioners in the matter. No coercive action shall be initiated against them. With the above observation, the writ petition is disposed of.
Item 6.
In this matter, we were directed to file an affidavit in operation matter. My colleague, Mr. S. Sattar, is actually handling this matter, but due to his mother's ailment, he is unable to obey today. He's asked me to make a request before this court, make a prayer.
What is the matter? What is the matter?
Lordship, the
It's
matter,
basically-
my matter pertains to, I am the beneficiary of PMAY house, my lord, that was allotted in my name, my lord. And 2 installments were given to me. And in terms of the, as per terms and conditions, I have constructed almost 50% of the house, my lord. And thereafter, that by this impugned letter dated 26/9/22 from the BDOs and my lord, my installments were kept on hold, my lord, remaining installment.
Why?
We are filing an affidavit, my lord, in this regard. As Mr. S, my colleague S. Sattar is handling this matter. Due to his mother's ailment, he is not able to obey
But
today.
the mother's ailment is all fine, but this is a 2022 matter.
Yes, ma'am. We're filing it within 2 weeks. Ma'am. We only sent for vetting. It's only required to be filed. Ma'am.
You know everything and you don't want to argue the matter.
Today, actually, we're not prepared. Ma'am.
And my bank account
Yes, sir,
where
will be-
that installments were deposited, that has also been kept on hold, my
I
lord.
had had
I'm-
Mr. R. H. Learned Counsel for the petitioner. That is the amendments made in the petition. Mr. M. Devnath, Learned Counsel, Learned Standing Counsel, PNRD Assam submit that his colleague who is handling the brief is not available today due to a medical emergency in the family. The Learned Departmental Counsel also submits that counter affidavit has been prepared and has been sent for vetting. Therefore, within 2 weeks' time, the same will be brought on record. Who's, you are appearing for?
For the bank lots. For
Yes.
respondent number 7 also.
Mr.
W Sharma lots. W Sharma.
W. Sharma, learned counsel is present on behalf of the respondent number 7. On the request of Mr. Devnath, 2 weeks further time is granted as last opportunity for to the official respondents of filing affidavit. Let this matter be listed again after 3 weeks.
Much over.
Highly.
For hearing item 8.
My senior is on legs at port number 1. So part matter. The last occasion, my senior has argued that the finding arrived in by the disciplinary inquiry officer is without any evidence. And we have submitted a list of dates. This is a there's a penalty of reduction to a lower stage in the time scale of pay by 4 stages for 4 years. So these are our submission. The charge sheet does not contain the list of witnesses who will prove the documents mentioned in section 3. The allegations are available at page 45, on which the employee was given the
So
punishment.
records are available? You got the record? All right, yes, let's go to the list of date.
I'm sorry, madam.
Yes, yes.
And on the last occasion, I was reading the judgment of Punjab National Bank, where in support of my submission,
This matter was heard quite some time back, so some refreshing will be required.
Malas. Here is a case where he was a bank manager. Now, 4 persons had opened bank accounts, and there was a fraud committed by some other persons, and overdraft to the extent of possibly 50 or 55 lakhs.
84 lakhs.
84 lakhs.
Loan was sanctioned against the LIC policies and subsequently it revealed that all LIC policies are
Fake. Fake.
So, and it was seen that the person concerned, the bank manager, instead of sending the LIC policy through messenger, he sent it through the person concerned who wanted to have the loan. And he took the advantage. And I found that it is surprising that a dismissal or discharge has not been punished. I asked the bank officials on several occasions, why such lenient?
He must be a good officer, Mr. Majumdar.
My lord.
Your client must be a good officer.
Well, there is no charge in the charge sheet that I was a party to that.
That may be the reason,
There
but
is
he
no
was
charge.
negligent.
No, they would say it is a case of negligence.
Negligence.
Yes.
And that
Yes,
is
they
why
are
the
saying.
Indian
And with the experience one has in these matters, I can say that your client is a good officer.
Yes.
Otherwise, they would have thrown him out. The 84 lakhs has gone down the drain.
My lord, then in that case, my lord, the respondent like
84
will have to, respondent will have to also say that persons who were having better control about the entire affair, they were given lesser punishment. Why?
That is different.
That is different.
But they were also punished.
They were also punished,
He
but
is
they
still
were
in service. Your client is still in service.
still in service. But I am challenging the order of punishment on certain grounds, the major. And I have handed over, just jotted down the points on which there are 8 points on which I am challenging.
Yes.
Number 1 is, along with the charge sheet, my lord, they have got their own conduct rules, which says along with the charge sheet, you have to give a list of witnesses. Your lordship is aware, in every proceeding, list of witnesses, list of documents in support of the charges. That was not done. Number one. Number two, my lord, while the hearing started, not a single witness was examined by the bank to prove the documents. Yes, my lord, strict rules of evidence will not apply in a disciplinary proceeding. But then the documents which were proved by whom? Inquiry officer cannot himself prove the documents, my lord. Supreme Court is very clear on that. Not a single witness was examined.
What was the basic charge against your client?
Charge,
What
my
is the
lord, there were as many as 8 to 9 charges, of whom, my lord, this is another ground on which I am challenging. All the charges were not held to be proved by the inquiry officer. Inquiry officer said that some of the charges, most of the charges are not proved. Now the disciplinary authority deferred. And my lord, law requires that if even the rules, in the rules also they have inserted that if the disciplinary authority desires to differ with the findings of the inquiry officer, then they will give a tentative view on which they want to differ on the findings of the charges. Then the delinquent will be given an opportunity of submitting his reply. To that extent, it is all right.
Punjab and Sindh Bank judgment.
Yes, my lord, yes, that was the, my lord, then we submitted our reply. Now thereafter, our reply was not considered and charges were not held to be proved, which is the requirement under the law. Thereafter, the punishment was meted out. How could the punishment be inflicted, my lord, without holding that the remaining of the charges, which were held to be not proved by the inquiry officer, but the disciplinary authority now says that since we give a tentative view to you that we will differ, so now we are imposing the
No,
punishment.
so they have not differed.
They have not differed.
So, but still some charges are proved.
Now the question is, my lord, on those charges, what will be the punishment? We don't know.
Where is the lenient punishment? Even if we assume it's
Which charges are proved? Let
My
us
lord,
see charge
Lord-
numbers.
Yes, my lordship may kindly come to straightway to page 47 for a moment to see which are the charges which are proved. My lord, unfortunately, the inquiry officer's report thereafter the disciplinary authority gave me a notice that they are going to defer. That your lordship will find at page 118, running page 118 is a part of the additional affidavit filed by the writ petitioner. My lord. There I have annexed that. There it is clearly mentioned which are the charges not proved by the inquiry officer, and then they desire to hold
Page
the
one
state.
one eight.
Well, page 118. Different. No. I'm sorry, madam. I'll take the lordship to page 66 of my writ petition, madam. From there, I'll show, madam, which are the charges which were held to be not proved. Page 66. There is the notice given by them seeking to differ with the findings of the inquiry officer. Page 66.
Yes, please.
Charge number 1 was not proved. Lordship has got, madam, page 66. Charge number 66. Charge number one not proved, 2 proved, 3 not proved, 4 not proved, 5 proved, 6 not proved, 7 not proved, 8 proved. So, my lord, out of 8, 1, 2, 3, 4 of the charges were 5 of the charges were held to be not proved by the inquiry officer. Then they served me a notice, which will be, your lordship will get at page 11. No. Page 1.
2, 5, and 8.
Yes. Out of 8, 3 were held to be proved, the rest were not held to be not proved.
No.
Now they gave me a notice and I submit my reply. Page number two.
So what are these charges 2, 5 and 8?
My lord, that will also will get at page 47, my lord. From the statement of imputation, what will get.
That is a serious allegation.
So are you denying this, that you are not handed over to the?
Yes, no, he has not denied.
My lord,
No, just for understanding it,
my lord,
insofar as charge number 2 is concerned,
two, my lord, yes.
are you denying that you are not handed over to the loan applicants
No.
and send it directly through official channel to the LIC office?
My lord, that
No, not
I,
denied.
that I have explained in my reply, in my appeal, why I did that. There was no negligence so far as giving that, because at that stage, my lord, there was nothing on record to show that these accounts were fake. The savings account which were opened by those persons. Now, at that stage, my lord, I said that in order to do some business for the bank, I gave it to them so that they can get the verification. Because the reply I have seen, my reply is a very short one. Subsequently, in my appeal, etc., I have explained in detail.
Then come to allegation number 5.
5 years. 5 is LIC police have been approved by the central board as specified securities under regulation 61D3 of SBI general regulations only for the limited purpose of staff advances. Thus, she thus violated bank's instructions by treating these LICI policies as specified securities for overdraft limits sanctioned to public.
Only the staff can avail the loan through LIC policy.
And the loanees were not staff, they were
No.
outsiders.
They were actually.
And where is the order of penalty?
My lord, penalty that will find at page 83, my lord. And relevant part is at page 85.
He has already served the penalty.
But
Penalty has already been served.
sir, but it says that my lord, if you lordship reads the entire penalty, reduction to a lower stage in the time scale of pay for 4 stages for a period of 4 years, with further direction that the officer will not earn increments to pay during the period of such of reduction. And on the expiry of such period, the reduction will have the effect of postponing the future increments of this pay. This is the penalty. In terms of rule 67F of the SBI OSR.
Let us read this order once at page 84,
84.
or maybe in 5 minutes we can start.
Right.
I'll just rise for 5 minutes. Calling. So, Mr. Majumdar, I have understood the length and breadth of your case.
Right.
Please focus on 2 aspects of the matter. You see, in a given case, procedural lapses, etc., may have a very fatal bearing.
Right.
But the court will have to see what is the prejudice that has caused to the petitioner. So we will proceed on the ground that only the 3 charges that have been proved would at best have been the basis for awarding the penalty. The disagreement part will ignore and say that since there was no communication, there was no disagreement, we'll treat it that way. But in respect of the three charges which were proved to be
Inquiry officer.
established before the inquiry officer, there also, at least couple of them appears to be quite straightforward and serious in nature. Number one is using LIC documents as security for granting loan. That, as Mr. Dasgupta says, we'll ask him to substantiate. This is a scheme which was applicable only to the employees and not to outsiders. So the bank manager could not have cleared it, regardless of who did what,
Right.
who else did what else. So this is a negligence, and secondly, he has sent back the letters along with the policies to the loanees themselves, instead of processing it through official channel. As a result of which, the fact that these were fake documents did not come out. So after the loans were given, those turned into NPS, and since the LIC policy documents were fake, the bank could not recover it. So there has been loss to the bank. Now, let's take it that unless your client denies
Right.
this allegation, this could be sufficient to justify this present penalty. What evidence do you want? What list of witness you want? He has himself agreed. If he has done it, then the matter will straight away come to the realm of proportionality. So is the punishment awarded not proportional? One would very rarely tend to agree with, I would very rarely agree with Mr. Dasgupta being the bank's counsel, but I think they have been lenient.
Yes, yes. They're very, very lenient.
This is enough ground to sack it.
Yes, it was
that. Before you proceed further, please consider this. It is not a case where charges have not been proved at all against your client, right? Assuming that your arguments of non-furnishing of witness, etc., is accepted, the whole thing goes. If the court accepts that regardless of this, there is no prejudice caused, because on the main charges, the position is not denied, or at least the factual position is accepted. Then the question will be whether the issuance of notice of disagreement and non-consideration of the reply has in any manner vitiated the order of penalty. If that view is sustained, then the matter will be sent back to the authorities for fresh consideration and thereafter a decision on penalty. Now that would also expose your client to the possibilities of a higher penalty. Because court cannot say that you give a penalty this much or less than that.
Court cannot.
So that is a possibility which was crossing the mind of the court. And therefore this exercise, because you can go through the motion, go through the process and point out various facts. But at the end of the day, their allegation, basic allegation is, regardless of form and structure, is that he as the manager has processed the loan based on fake LIC documents, and those, the fraud in this could not be detected because the procedure adopted by him by sending the documents to the loanees themselves was not the approved standard procedure followed by the bank. This much, whatever may the justification.
Well, I have specifically said this is the standard procedure followed by the bank, which I have specifically taken this stand. Well, subject to what your lordship is indicating, I have understood, my lord. Possibly I'll have to take instruction. But otherwise, the argument that I can make, or I would like to make, is that, my lord, so far as the punishment on the basis of the charges which are given by the inquiry officer held to be proved, possibly subject to correction and subject to what your lordship say, my lord, it is for the authority to take a decision what punishment should be there on the basis of these charges. Otherwise, as far as even these charges are concerned, my lord, my submission will be that I have taken a plea that even the charges which are held to be proved by the inquiry officer cannot be said to be proved on the ground, that there is absolutely no evidence for those charges also. Because not a single witness was examined to prove those charges also, my lord. But otherwise, what your lordship is ultimately indicating, I have understood, my lord.
No, then in that case, you have to forego that part of your argument. Because if you also argue on the point that there was no proper consideration of your application,
Yes,
and if you succeed in that, then the matter will be remanded for a fresh consideration. That would also expose your client to a higher penalty.
that is there.
There is this possibility
Going for an inquiry.
to inflict higher punishment.
Lordship, ma'am, I have understood, madam. And let me take instruction, madam. Let it be taken up later tomorrow. Tomorrow itself I'll take the instruction.
I think he should consider all these things, not directly.
No, but then otherwise he's entitled to argue his case on that count.
I can argue, but let me take instruction on this, madam. Let me first come up with the first point first, madam.
Because what is
Possibly,
not denied is,
Possibly, madam.
what is
Let
not
us-
denied is that he was the branch manager,
Yes.
that these loans were sanctioned by him.
No, my lord, it was not.
No,
sanctioned.
he played a part in
He
the,
was a party,
no, he played a part.
2-3 persons were there.
2-3 persons were there,
Higher
and
officers were.
we will not even look at what has happened to others. That's
Right.
not the scope of inquiry. He played a
No,
part.
but your lordship will not totally ignore it because others who were discharging higher responsibility than him
Hmm.
were meted out with a smaller punishment. I have annexed the documents and this is one of my.
Then are you arguing on the proportionality of
Well,
punishment?
if I at all argue on the proportional, then I'll show that. Well, now let me take instruction. Let it be taken up later tomorrow. Man. Because what your lordship has indicated is quite relevant, man. I think.
It is up to him, my lord. I think, my lord, he should be satisfied with this punishment. It is personally, not
No,
officially.
maybe he also thinks about his client. doesn't
My
think.
lord, Let my client.
And
also
if
think.
it goes back, my lord, he may face other other consequences.
Because exoneration may be difficult in this. case.
My lord, yes, my lord, I otherwise planned to argue that also on the ground that the lacuna which they have in their proceedings is such that now they cannot be given any opportunity of filling up that.
No, no,
No, even if we
I-
assume
I
that
was-
we
I was
have a lot
thinking-
of lacunas,
My
then
lord.
also, my lord, we have a case
My lord,
because of the fact he has not denied these allegations.
Mr. Majumdar,
my lord,
you will definitely be aware and conscious of the fact that
Right.
this is not a criminal trial. There is
True.
no need to prove any charge beyond doubt, right? If a charge sheet contains charges which are either not well formulated or not well established, then the court can ignore those charges and focus only on those allegations
which are.
which are borne out from the record of the court case. So it is in that context. The fact here remains that your client had some role to play
Yes.
in sanctioning of these loans.
Right.
Now, this is a financial institution.
That
And
is
they are
the-
saying that
that is the
they have
problem.
suffered losses. So some element of negligence is what they are alleging. That let us take it as the minimal.
Right.
Negligence leading to pecuniary loss is a pretty serious matter in a bank. How does this court sit over and say that, sorry, you have not examined this witness, you have not tendered this document, so everything is set aside?
Now, but technically, what I was thinking of arguing, since today I'm not arguing, is that Supreme Court has made it very clear that there has to be some evidence. If I can show your lordship that for not examining any of the witnesses, it will be a case where there is absolutely no evidence, then what will happen? This is what I was technically thinking of arguing. Now that I'm taking a short time for taking instruction, let it come up.
Day after tomorrow, you could be number 14 or 15 in the list of parted matters.
Then when we- Friday,
Friday.
because what I'm saying, my lord, is what your lordship is indicating, at least I have understood. Let my client also understand. And let
We'll
us-
have it on Monday on the request of Mr. D. Majumdar, learned senior counsel, appearing in this case for the writ petitioner. This matter be listed again on Monday, that is so and so, as a fixed parted matter. Mr. A. Dasgupta, Learned Senior Counsel, assisted by Ms. B. Das, is present on behalf of the respondents. Assisted by
want to
Mr.
argue before your
Vishwas
client.
For petition.
I have to argue from it.
Milord, he has to argue before his client.
Yes, yes.
What is it?
Sometimes it is
No,
necessary.
but
He should be made known.
the court is open. I
Well,
am not saying that
I am
any
just-
particular conclusion is what we are heading at. But of course, if the matter is remanded, then
That is what my lord is making me. A little, that is why I want to take instruction from.
because ordinarily these
I
are
cannot-
matters where dismissal is what normally follows in banks. Banks don't tolerate pecuniary loss. They are very limited tolerance.
And I have, my lord.
Well, I have some cases, that case relates to State Bank of India, where it has been stated that all time all the documents are not required to be proved. Because I have given the documents, you have perused those documents. And the contents of the documents
was-
are admitted.
There was no proof of
There is
absolute.
one case is
No
2013 to SCC,
Well, unless I can show that there is, it's a. case of no
2013
evidence,
to SCC,
yes,
page
ultimately-
740.
All right.
There is a case between the State Bank and the other. I am not placing all this.
But is rigors of evidence that applicable in a department
no.
proceeding?
No, but then Supreme Court says there has to be some evidence. Now, if there is no evidence, then what will happen, my lord? This is what I'm saying. my lord.
So you are saying no witness examine, no
Not a
document.
single manner. How the documents, presenting officer presents it, then inquiry officer accepts it. This is not the way. Supreme Court says there.
But are you denying those documents, disputing
Yes.
those documents?
No.
Well, a document per se doesn't prove the charge. This is the problem.
No. Here, Mr. Majumdar,
Right.
of course, you are yet to argue
Right.
and in all probability, you have very weighty arguments to make. I'm not cutting you short on that,
Paragraph,
but
paragraph
purely
9.
on an academic footing, you see, proof of a document
Right.
as in a civil suit or in a criminal trial is one thing. In a departmental proceeding, evidence ordinarily means material. There has to be some basis. Now, there is also a matter of admission denial in a civil proceeding. This is a civil proceeding.
Here it is not.
So if you do not deny a document, where is the need to prove it? Once an official document in a bank's, this is a domestic inquiry. This inquiry is a domestic
My
inquiry.
lord, I'm just pointing out, although today we are arguing, so far as charge number 2 is concerned, there can be one document to show that yes, it was directly sent to the LIC for authentication. But the charge is not that. Charge is that this is not the practice. And I have taken specifically that this is the practice regularly followed.
So where is the document to show that?
Well, a regular practice that I've taken a plea. Now, if they do not show anything that no, it's not a regular practice. So merely because I have sent it for authentication directly will not itself prove the charge number 2. This is my submission.
What they are saying is you have relied upon the loanee, the
Yes.
beneficiary,
Yes,
to verify the document.
yes, because this is the
And
practice.
he has practiced a fraud, led to the loss.
Manu, as soon as this was discovered, I informed and I lost the FIR.
No, nobody's saying your complicity is there. Nobody's saying. It's not a case of complicity.
On the question of negligence.
It's a question of negligence.
All right, Monday.
That you must, first of all, know it very clearly and your client should also understand.
Madam,
There is no allegation of complicity.
madam.
The allegation is of negligence. Now, if somebody comes with a loan application to the bank and XYZ officers, including a particular officer, says, all right, we'll give you the loan on the basis of this. Please go and get us a certificate of authentication. And he comes and gives you a false certificate, regardless of if there is any procedure, any SOP, any notification. That's wrong. Unless the contrary is proved, it's wrong. It can't be done. It cannot be done. And then it turns out that this is a fraud and it led to the pecuniary loss to the bank. It is obviously wrong. What witness and what? See, the law is not a stultifying subject. Law will have to be
Depends on
applied
the
on
facts,
facts,
facts
on
of-
each facts. So in another matter, if there is a overwriting fraud in the records,
This may be of some,
etc., their non-examination of a particular witness
may be fatal.
may be very vital. But here,
True,
whether
but
there is a
This will
notification
differ from case to case.
or not, assuming that there is no notification, how can the person say that this was in my best judgment, the correct procedure? And then the people take advantage. This can't be the procedure. There can't be a notification for everything. After all, officer in the management level has to have some discretion.
All right, I'll let you take the instruction.
These are questions which will be
Madam.
relevant.
Madam.
Yes.
The 9 and 10.
May it be the, my lord, I am appearing for item number 9. Your lordship may peruse the order dated 23/5/23. The most relevant is para 11. Though there was a stay order on the termination of the president and the secretary of the cooperative society, para 11, it was further provided that the event of register deems appropriate. We will rehear the matter relating to the appointment of the petitioner, president, chairman of such and such, pending will not be a bar. So thereafter, the registrar took the hearing without us and passed an order. We have filed another writ petition challenging that order. My lord, that will be coming on Friday. So let this matter be come along with that. And the notice has been issued in this case.
But that writ petition you have filed, this has become infructuous.
My lord, infructuous,
My lord.
but what I want to say, it is a continuity of that. That is why let the matter be.
All right, we'll close it by saying that any issue surviving in this writ petition can be urged in the new writ petition.
My lord, that is.
Yes, ma'am. And big last order, Lordship may kindly have a look. Honorable Court order. It was my submission. This become infructuous. And they have said that this may be taken for final disposal. This will become
Just a minute,
infructuous.
just a minute. Please take your seat.
My lord.
No, I'll protect your client's interest.
My lord.
I'll protect your client's interest. Let
ma'am.
me understand what is the,
Ma'am.
yes.
Taking the residence.
So there are two writ petitions.
No, my lord.
Why
One-
two writ
Yes,
petitions?
One file.
And
Yes,
Filed by
number 9 is filed by,
My lord, 9 is filed by Syed Hussain Barbuya.
and number 10, what is the issue, number 10?
Your Lordship, though the director has, after hearing the parties, passed an order to directing the ARCS and register to hold a fresh election and selection of the president, vice president, it was not held. Therefore, we have filed for direction.
Achha, so now your writ petition has also become infructuous. Because he was appointed the chairman. That goes because the register is heard and passed an order
On the basis of our complaint.
on the passed an order holding that your appointment as chairperson is invalid. And he was aggrieved by the fact that no such meeting was being held for appointment of chairperson. So once you are held invalid, now what is to be done?
If a direction to the RCS to hold a fresh election, going all the notice to all the person, all the board of directors.
My lord, till then, because I have filed a repetition challenging that invalidation order. My lord, if there is a direction, then that becomes.
No, there will be no direction.
No direction.
So since his appointment has been held to be invalid, consequences under the law will follow. That's what will happen. And in your case, we'll make it clear that we are closing this as infructuous by granting you liberty to assail. What is the date of the order register?
My lord,
15th of
15 July 2020.
2023.
15 July 2023.
Lordship, I have given a copy to my lord file last week.
It is the second order. Earlier, one order was passed after hearing the parties. They filed the petition.
This is the first
Sentencing
one,
order. It is the
item
second
9.
order.
What is the first order about? Where is the
It's
first order?
page 56, my lord, in the item 9 writ petition. WPC 2797. Five copies in the page 56, 57.
56 order was stayed by this court.
Till returnable debt, lordship, paragraph 8. Only because the observer was not heard, my lord. Only because this honorable court has stayed the order till returnable debt and liberty has given to the register to rehear the matter. After this honorable court order, the register has passed the rehear the matter and passed the order on 15/7 order, my lord.
And that has been challenged by a new writ
New writ petition. So this matter become infructuous, my lord.
because I was continuing because of the stay order.
You were originally appointed as chairman of the society, board of directors.
Page 56 of that item number 9. And that was the impugn order by which I was appointed, and then thereafter, my lord, complaint was filed, and that's why I was removed. Appointment order copy. At page 54, I was. Okay. You got the appointment list, সেটা বলুন। Page 47.
Take down, heard Mr. P.K. Roy Chaudhary, learned counsel appearing for the writ petitioner in WPC number 2797 of 2023. I have also heard Mr. S. Islam, learned counsel for the writ petitioner in WPC number 2837 oblique 2023. Miss M.D. Bora, learned standing counsel cooperation department, has appeared for the official respondents in both these writ petitions.
Hello.
First up. The writ petitioner in item 9 was originally appointed as the chairman of the Nakuti, NAKHUTI, Nakuti Samavai Samiti Limited. However, on a complaint lodged by the private respondent, you are the private respondent in the by the private respondent numbers 5 to 13.
Because they were not.
The Register of Cooperative Societies Assam, that is the respondent number 2,
Two, my lord.
had passed impugned order dated 28/4/2023, setting aside the appointment of the petitioner as the president stroke chairman of the SS Limited, as well as the appointment of one Siddiq Ali, SIDDIK, Siddiq Ali, as the vice chairman of the said society. Agreed by the order dated 28/4/2023, the writ petitioner has approached this court by filing WPC number 2797 of 2023, stopped by an interim order dated 23/5/2023, passed in the said repetition. This court had stayed the operation of the order dated 28/4/2023, but had provided leave to the respondent number 2 to rehear the parties on the question of appointment of the petitioner in the post of president of the chairman of Nakuti SS Limited. And pass appropriate order therein. Full stop. Accordingly, the respondent number 2 has conducted rehearing in the matter and thereafter issued order dated 15/7/2023.
Leader. What's the name?
Holding that the election of chairman and vice chairman of the Nakuti SS Limited in the BOD meeting held on 30/7/2023 was not convened as per the procedure laid down under the law. Accordingly, the original order dated 28/4/2023 was upheld. Full stop. Acha, the report you write the appointment of writ petitioner and one so and so as president and vice president of the Narcotics SS Limited in the meeting of the BOD held on 30/7/2023.
My lord, in place of appointment, lordship may record selection. They have selected.
Selection or election?
Selected.
After election,
Vote of members, they were vote of director, they are selected.
Acha, instead of appointment, right selection. First of all. Mr. Roy Chaudhary has argued that he has instructions to challenge the order dated 15/7/2023 by filing a fresh writ petition.
Already filed. Already filed.
All right, already filed. It will
not
be listed.
listed. Not listed.
Listed on Friday.
Submits that he has already filed a separate writ petition. It is numbered.
My filing number WPC
Filing,
976.
Petition challenging the order dated 15/7/2023. Full stop. In the meantime, it appears that WPC number 2837 of the 2023 was preferred by the petitioner therein. Petitioner
They are
therein.
the board of directors.
Huh?
They are the board of directors.
Was preferred by the board of directors of the aforesaid SS Limited, who are the original complainants, alleging that no action has been taken for selection of,
Next meeting for selection.
no action has been taken by the authorities for convening a fresh meeting for selection of president and vice president of the SS Limited. First of all, since the uh, selection of the petitioner as the president of the SS Limited, and Sri Siddiq Ali as vice chairman of the said committee has been held to be illegal, subject to the challenge made to the notification dated 15/7/2023. The said persons cannot continue in the office of president and vice president of the SS Limited. However, once an order is passed to that effect by the respondent number 2, law would now take its own course, subject to orders, if any, that may be passed by this court. First off, if that be so, nothing further survives for adjudication in both this writ petition at this point of time. Mr. Roy Choudhury submits that he would not oppose any order closing the writ petition, provided his client is granted liberty to urge all legal grounds in the newly instituted writ petition, challenging the order dated 15/7/2023. The learned counsel appearing for the department as well as the private respondents have not opposed such a prayer. In view of the above, these writ petitions are being disposed of by providing that subject to further order, if any, passed by this court in the writ petition preferred by the present petitioner in item 9, assailing the order dated 15/7/2023. Appropriate steps as may be permissible under the law be initiated in the matter. Both the writ petitions stand disposed of. In view of the orders passed in so and so and so and so, IS stands disposed of. Okay.
Obliged, my lord. Lordship may keep my order that part of the record.
Copy of the order dated 15/7/2023 be retained in the record.
My lord, deeply obliged, my lord.
Part 2 matters, item 1.
What is this matter? Which year? Let's see, we'll dismiss it. It was called earlier also. Who is the council?
But my seniors and legs in court number,
We cannot, what do you want me to wait?
not wait, your
I
lordship.
will tell him that I'm waiting.
Just bring.
Whenever he finds time, he can come.
This cannot be matter, your lordship, just for today, your lordship, just.
You are who?
Does not have to brief with me, your lordship.
Huh?
Does not have to brief with me, your lordship. You can-
This is item number 1. of the
Yes,
party.
absolutely, your lordship. There's no disputing that, your lordship. Just one day of your concession, your lordship. I'll not argue further on that. Any further delay, your lordship.
Lordship, we have filed detailed evaluation, more than 1 month, 3.
All right, next call, if you don't. appear,
Absolutely,
I'll
your lordship.
dismiss
I'm
it.
grateful, your lordship.
Yes.
I'm good.
My percentage.
Item 3. Item 4.
You are in item
Item number 3,
for,
private respondent.
who is the petitioner's counsel? Mr. Saiwala, you are there in item 3?
Well, he is arguing, my lord, that actually, we have nothing to do with this matter. Municipality has to do, my lord. We are the development authority, my lord. So we don't have anything to say, my lord. We are, my lord, respondent of 5. It is the respondent of 4, my lord, who has,
He is called
we
earlier.
have been raised a party only.
Item 3, is it?
Yes.
None appears for the writ petitioner on call. Mr. G. N. Saiwala, learned senior counsel, is present on behalf of the respondent number 5. Mr. N. Goswami, learned government advocate, has appeared for respondent numbers 3 and 7, and Mr.
No, he is along with me, my lord.
This matter was called even on earlier occasions, but the petitioner's counsel had failed to appear in the matter. This is a writ petition pertaining to year 2012, and therefore it appears that the writ petitioners have lost interest in pursuing the matter any further. This is civil bench 4. Huh?
For part 2 matter, civil bench.
Pursue the
divided.
matter any further. In view of the above, this writ petition stands dismissed for non-prosecution.
Item 4. Item 5 and 6.
Who is there in item 4?
Item 4.
None appears for the petitioners. When the matter is petitioners, when the matter is called up before this court for hearing today, the respondents' counsel are present. This writ petition pertains to the year 2012, and therefore it appears that due to long lapse of time, the petitioners have lost interest in pursuing the matter before this court any further. In view of the above, the writ petition stands dismissed for non-prosecution. Item 5. This is item 4. And next item. 5 and 6 call up. Call up.
Item 5 and 6.
What is the matter? Let us see. Then 5 and 6 has been fixed for 24th of August.
24.
Yeah, already it has been fixed. Earlier.
7.
Hey, please. You know, this matter may be taken up day after tomorrow. I have carried a long brief. Day after tomorrow.
Let's see if time permits.
Obliged.
So both sides ready? Any matter with both
yeah.
sides? Huh?
13 and 14, my lord, our side is also there, madam.
Item?
13 and 14.
What is the matter? Let's see.
14 is merged with 13, my lord. 13 is to be taken up.
13 and 14. Yes. My lord, the petitioner, my lord, he was allotted two plots of land of 1 bigha, my lord. Your losses may turn to page 15. My lord, the 1905 of 13, my lord.
Page 15.
Page 15, my lord. Thanks, everyone. This is that I could order, my lord. The authority by Karjan District Council is pleased to settle land periodic pata with the following. Umesh Singh, 1 bigha, my lord. Doc number 91. Then with the same doc, my lord, another order is there at page 17. Similar order, my lord. Under 1 bigha.
So two plots of 1
Two.
bigha.
Yes, my lord, two. Contiguous plot, my lord.
Then
In this aspect, my lord, the periodic pata has been issued, my lord, page 19. Page 19 and page 21. Yeah, periodic pata. The Assamese person is also annexed, my lord. 19 and 21, both one and bigha.
yes,
Now, land holding certificate is also issued in favor of the petitioner, my lord, page 23. Then, my lord, later was issued, my lord, by the Joint Secretary Revenue at page 25, my lord. I was directed to stop my construction, my lord. This is the subject matter in the second read petition, my lord, so I did not proceed because a subsequent order is provided. I am directed to issue notice to request you kindly to stop the construction work on a plot of land settled with you by the office number so and so and so and so. And the land, as the said land is reserved for Fisheries Department and the matter is under review. This is what they have said, madam. I am paying, my lord, land revenue also. That receipts I have enclosed, page 26 and 28.
so this order is of 2013.
13. Then now, my lord, it page 30. This is the main order. In pursuance of the executive committee resolution number 4, that is the authority of the Karbi Anglong is to withdraw the land settlement order issued to Umesh Singh by memo number so and so, respectively at Tipu Town block number 4, the said land are government reservation land to Port Fisheries Department. DC therefore directed to issue the patta so and so decided to that the patta issued to Umesh Singh be cancelled immediately. Well, patta can be cancelled without giving a notice, without anything. Now they filed a, my lord, affidavit also, where they have said, my lord, that their main ground was, my lord, it was reserved for Fisheries Department and the council has not granted the same, my lord, approved the same. That is the, my lord, ground.
Council has not approved the.
Council has not given the approval, my lord, for the settlement. That is the ground, my lord, there. In para 7, my lord, your losses may see their affidavit. Para 7. 7 and 8. That the deponent begs to state that Rule 26 of settlement rules from Assam Land Revenue Regulation provides a subject to the general control of the state government. Executive committee so and so and so. The commissioner shall have power to confirm all settlement that the executive member is and to cancel any settlement made contravention of this rule after giving release for the opportunity of being heard. Rule 66 of they themselves say being heard, nothing else. Rule 66 of settlement rule provides a western townland shall be settled by deputy commissioner in accordance with rule 67 to 71, subject to confirmation by state government that the executive committee Karbi Anglong District Council.
but a lease was granted in favor of the prisoner, was granted without confirmation of the executive committee of the council as such. Lease granted to prisoner not recorded to the rules. The opponent back to state the entire land covered by lag number 91 Dipu town was reserved for Fisheries Department of Government of Assam, and due to oversight manipulation, a part of the land of 2 bighas under the said dag was settled the petitioner. A plot of land measuring 1 bigha, 1 lacha, dag number 91 was settled the petitioner on annual pata basis by an order at so and so. Subsequently, another plot of land of 1 bigha, 1 lacha was settled the petitioner on annual pata basis on so and so. As per normal procedure, the land in the lease town area converted periodic lease after 3 years on fulfillment of terms and conditions, but in violation of normal procedure, the periodic lease was granted to prisoner after completion of 3 years. The illegal and irregular settlement land in favor of the petitioner was detected on receipt of a complaint lodged by District Fisheries Development Officer. On receipt of a complaint, the assistant,
Who is in possession of the land?
I am in possession. I have already boundary, my lord, I have some construction also. There. Now, my lord, my father has filed a RTI application, my lord. Your losses may see, my lord, in my affidavit reply. Page 10 is the, my lord, my application for seeking under RTI Act. Now they have replied at 11. My lord, page 12 is the report. My lord, that is very important. Kanungo has given the report. My lord. In pursuant to application submitted by applicant, TSO by letter number so and so, and the RTI Act has accepted the same after inquiry was made the following information has been obtained as to how Ramsing has been allotted, Exna and Myadi Patta is sought by the applicant. From the Jawandi, it has been seen that Moja, Jamuna Nagar, Dipu town block number 4, Sita number 1, flag number 91, land measuring 11 bigha 2 lacha has been noted for the Fishery Department. However, the said Fishery Department has not yet been given any allotment by the Jilla Parishad. No, nothing has been done, my lord. Just one noted. On perusal of the test map, the said land, it has been seen that land covered under the cancelled dark number so and so missing T. Has enclosed the said land by erecting bamboo fence surrounding it. Thereafter, height order of the Jilla Parishad out of the town land measuring 11 bigha 2 lacha under dark number 91 Umesh Singh T. Ram Singh T has been allotted 1 bigha of the land under dark number so and so. Exna Kachapata being number 541 and 1 bigha under dark number so and so. Exna numbers has been separately divided. In regard to said allotment, land see Umesh Singh T has submitted 5 form during the period of the land covered by dark number so and so had enclosed and surrounded by erecting bamboo fence and also field level the same with land for constructing a house. On submission of the application in 5 form, the Jilla Parishad Secretary by revenue so and so dated, so and so order dated 1 bigha land has been divided from dark number 91 and converted to dark number 2201 covered under patta number 541 in reference to the letter of the secretary in charge of revenue by memo number so and so passed an order directing to allot the land measuring so and so under extra patta number so and so. Thereafter, in reference to this application submitted by Umesh Singh T, conversion bearing number so and so by order of conversion letter so and so in pursuance of payment of premium regarding action was converted to 1091 Myadi Patta.
Land is a transfer subject.
My lord, but it is the inherent subject, my lord, under the 6th schedule under paragraph 3, we have the power to enact law. Accordingly, we have enacted the Karbi Anglong Land Revenue Act 1953 under the 6th schedule. By the said act, my lord, in respect of the autonomous council, my lord, in respect of the state government, it is the executive committee. Commissioner means the executive member in charge of the revenue department, and the revenue officer is the secretary of the revenue. That is the, my lord, that by virtue of that act, we have adopted the Assam Land and Revenue Regulation for the purpose of the Karbi Anglong Autonomous Council. In this particular case, the land is reserved for the, my lord, Fishery Department. Oversight or manipulation or the influence of the persons, my lord, concerned, who is the persons, my lord, he knows better, my lord. But the land was allotted to him at that time. But subsequently on the complete.
No, land was not allotted to him.
Settlement, my lord.
Patta was given to him.
After
That
settlement-
creates his right over the land.
After the settlement, my lord, patta was issued.
Where is your power to extinguish right over land,
My-
title over land?
That, my lord, under Rule 26 of the Assam Land and Regulation, my lord. Lordship will look into Rule 26 of the settlement rules, my lord. That is only for settlement.
Mr. Saiwala, please take your seat. The answer, the outcome of this writ petition will depend on two things.
Yes.
Number one, after the creation of title,
Yes.
do they have the power to take away the title?
Cancellation of patta, my lord.
Well,
That is a rule 26.
Patta has not yet been cancelled.
My lord, Lordship, rule 26, my lord, settlement rules. Confirmation and cancellation of settlements. Subject to the general control of the state government, that is in respect of the council, autonomous council, my lord. The commissioner shall have the power. The commissioner shall have the power to confirm all settlements and also to cancel any settlement made in contravention of these rules after giving the leaseholder an opportunity of being heard.
So was he given the opportunity?
My lord, at that point we have not, my lord. My lord, that point is there, my lord. The opportunity of hearing required to be given as per rule 26, my lord. Our affidavit is silent on that. That is only the point, my lord, we have that lapses, my lord. But I cannot admit the lapses, but we have not clarified that point in our affidavit. So, my lord, the opportunity of hearing, but cancellation power is there. We have to give him the opportunity of hearing. Lordship may remanded the matter to the, my lord.
You take all this plea and.
Plea, all this.
My
plea,
lord,
my lord.
what I am submitting, my lord, 2009 4 GLT,
Hmm.
611. My lord, paragraph 11, your lordship, my lord. This is only settlement, my lord, but after patta is issued, my lord, there is no power, my lord.
So, Mr. Sahiwala, we can set aside this and you raise this point before them if they issue a fresh notice.
Praise God.
If they issue a notice, you appear and raise these points. Will, at the moment, we'll set aside this order on the ground of violation of principles of national justice. Correct.
Quoting rule 26, my lord, that no opportunity of hearing was given.
But only what I am submitting, my lord, that after the patta is issued, there is no power under the.
Lords may interpret that one, then rule 26, whether we have the power.
That is what, my lord, 2009 4 GLT also held, my lord. No power, my lord.
Two 2009 for 4 GLT, which para?
My lord, para 11. Para 11 middle, my lord.
All right, we'll record it as your submission. What is the second writ petition about?
The same part, my lord.
That is against the order, my lord, stopping the construction. So,
Both of us.
Which is against the order stopping construction? Which writ
my lord,
petition?
that is, I have already placed, my lord, here, that annexure.
Please tell me which writ petition is filed against what?
Annexure 25, my lord, annexure page, annexure 6 page 25 of this writ petition. That is the impugned order in the earlier case.
First, we will hear it next week then, because I have to do the homework.
No,
I'm
no.
asking the question, which writ petition is filed assailing what?
Oh, yes, my lord, that 1009 of 13, that is the stop construction.
One
the
double
same
zero
prayer.
nine.
1905 is the same prayer, cancellation of the, my lord, that is challenge that one also, my lord.
No, there is only stop construction order, my lord, at that time.
The prayer is there.
The next writ petition is filed by challenging 15/3/2013.
Yes, my lord.
Okay. All right, heard Mr. G. N. Sahiwala and senior counsel assisted by Mr.
H.K. Sharma.
H.K. Sharma and counsel appearing for the writ petitioner in both these writ petitions. Also heard Mr. J. Chutia, learned standing counsel, Karbi Anglong Autonomous Council. As well as Ms. S. Borua, learned government advocate Assam, appearing for the official respondents. Full stop. By filing these writ petitions, the petitioner is basically assailing the decision of the Karbi Anglong Autonomous Council to withdraw the land settlement order earlier issued in his favor, settling 2 plots of land, each measuring 1 bigha, 0 kata 0 lacha, covered by DAG number 91 of Deepu Town Block number 4, on the ground that the said plot of land was originally reserved for the fishery department. First up, it appears that based on application made by the petitioner,
My lord.
The secretary in charge, Revenue Department, Karbi Anglong Autonomous Council District, Autonomous District Council had issued order dated 1/3/2011 settling a plot of land measuring 1 biga 0 kata 0 lesser covered by that number 91 situated in Difu town, block number 4, Jamunapur in favor of the petitioner. Full stop. Thereafter,
It is earlier, my lord. I am sorry, my lord. The second order is 2012, my lord.
thereafter, by another order dated 6/1/2012, another plot of land, another adjacent plot of land measuring 1 biga 0 kata 0 lesser was settled with the petitioner, thus settling in total 2 bigas 0 kata 0 lesser land in favor of the writ petitioner situated at Difu town, block number 4, Jamuna Park, covered by DAG number 91. Full stop.
Well, after it was recommended by the Land Advisory Committee.
According
I have
to the
annexed that,
petitioner, the order of settlement was issued on the basis of recommendation made by the Land Advisory Committee of Karbi Anglong District. Full stop. Thereafter, the petitioner had paid the revenue oblique premium with applicable in respect of the said plots of land. Whereafter, Kiraj Patta.
Yes.
Bearing number 2426 was issued to the petitioner pertaining to the aforesaid plot of land. First of, in this manner, the petitioner
Well, two pattas,
started
my lord. Two pattas.
two pattas,
2464 and 2515.
2464 and 2515 were issued to the petitioner pertaining to the aforesaid two plots of land settled with him. In this manner, the petitioner continued to occupy the plots of land as patta holders and had also raised certain constructions over the plot of land. Full stop. It was at that stage that the Joint Secretary, Revenue, Karbi Anglong Autonomous Council had issued a communication dated 27/02/2013 addressed to the petitioner requesting him to stop construction work over the plot of land settled with him on the ground that the said land was reserved for the fishery department and the matter was under verification. Full stop. Since the petitioner was holding patta with regard to the aforesaid plot of land, being aggrieved by the communication dated 27/2/2013, the petitioner had approached this court by filing WPC number 1009 of 2018, assailing the aforesaid communication.
13, my lord.
2013, assailing the aforesaid communication with a prayer to restrain the authorities from interfering with his peaceful possession over the aforesaid plot of land. First stop. During the pendency of WPC number 1009 of 2013, the respondents have issued impugn order dated 15/3/2013, withdrawing the land settlement issued in favor of the petitioner on 6/1/2012 for land measuring 1 biga 0 kata 0 lesser and 1 biga 0 kata 0 lesser covered by DAG number 91 situated at Difu town, block number 4. Full stop. assailing the order dated 15/3/2013, the 13 WPC number 1905 of 2013 was instituted. The respondents have filed counter affidavit in WPC number 1905 of 2013, inter alia contending that there was some irregularity in the settlement of land in favor of the petitioner, which was detected at a subsequent stage only on receipt of complaint by the district fishery development officer, Karbi Anglong Difu, full stop. As such, the interim order was issued so as to rectify the anomaly in the land settlement process, thereby restoring with a view to allot the land to the fishery department of the district council. Full stop. Assailing the impugned orders, Mr. Sahewala submits that once a patta is issued in favor of a settlement holder, it said the same creates title over the land, and therefore the respondents cannot cancel the same, that too without serving any notice or giving an opportunity of being heard to the petitioner. In support of his above argument, Mr. Sahewala has relied upon a decision of this court rendered in the case of Jenar Marak versus Garo Hills Autonomous District Council and others, reported in 2009, bracket 4, bracket close GLT 611, to submit that once a patta is issued, the revenue authorities would not have any power of cancellation of patta. Full stop. The said submission of the petitioners council has however been refuted by Mr. Chutia by placing reliance on the rules framed placing reliance on Rule 26 of the rules framed under the Land and Revenue Regulation to contend that the
patta is required to be confirmed by the executive committee, and the commissioner and the executive member in charge has the power to cancel it after giving an opportunity of hearing.
any patta issued to a settlement order is required to be cancelled by the
Confirmed by the executive committee,
is required to be confirmed by the executive committee,
and the cancellation can be
the
done
council, and cancellation of patta can also be done.
by the executive member in charge revenue
By
after
the
giving an opportunity of hearing,
Executive member in charge, revenue, after giving an
an
opportunity
opportunity of being heard.
to the allotee.
Allotee.
Full stop. Therefore, it cannot be said that the patta once issued cannot be cancelled. Be that as it may. Even going by the requirement of Rule 26, it is apparent that no order of cancellation of patta can be issued by any authority without serving notice upon the allotee. Full stop. However, in the present case, there is nothing to show that any prior notice was ever served upon the petitioner. Therefore, the stand of the petitioners' counsel that the impugned order was issued behind the back of the petitioner and without giving him an opportunity of being heard stands substantiated on the face of the record. Consequently, the impugned order dated 15/3/2013 is hereby set aside. The writ petitions stand allowed. However, it is made clear that in the event any fresh proceeding is sought to be initiated in the matter, the same shall be done strictly in accordance with law and after serving prior notice upon the petitioner, giving him ample opportunity to show cause. In the event petitioner, show cause. Further, no action to dispossess the petitioner from the land under his occupation shall be issued unless a final order is passed by the authorities in accordance with law.
By the executive committee.
With the above observation, this writ petition stands disposed.
The order in the other mission will be also be said. 27 to.
Both the orders, the earlier order request 27.
7 to.
Construction
is the different
And 15/3/2013.
The status quo, lordship, earlier interim order was to maintain the status quo. So that if they construct, my lord, it cannot be subsequently allotted to the fishery department. So my lord, status quo in respect of the land till the.
That in his petition, how can we pass an order against? You can take your own decision.
Madam.
But you see, these are also suddenly for fishery department, 10 years.
My lord, off the record, my lord, who is the my lord father of the petition, my lord, he knows him better, my lord. So at that time, if the person is there, my lord, as insights.
Any other matter where both sides are ready for hearing?
You are 25, Lordship.
You are for whom? Petitioner. Ready for hearing.
Yes, my senior is ready for hearing
Where is your senior?
at court number 3, Lordship.
Who is your senior?
Mr. A. Rashid.
Huh?
Mr. A. Rashid.
And who is the other
Other side
side?
is government, Lordship.
Who is for the other side in this case? Item number 25. You let me know if both sides are present.